Hi, I'm Michelle Camacho, a criminal defense attorney here in San Diego, and I serve on the executive board of the San Diego Lawyer Chapter of the American Constitution Society. As an initial matter, I'd like to thank Joanna Schiavone of the Advisory Board of San Diego for conceiving the idea of this program. Thank you to executive board members Howard Wayne, Dove Fox, and Connor Sonskin, and the ACS national staff for their assistance in putting together today's event. Thank you also to our co-sponsors, the American Constitution Society at-large chapter, ACS Tampa, ACS Columbus, ACS Western New York, the Iranian American Bar Association San Diego chapter, and the Pan-Asian Lawyers of San Diego. And last but not least, thank you to those of you who have dialed in from across the country. The ACS works to uphold the Constitution in the 21st century by ensuring that law is a force for protecting our democracy and the public interest and for improving people's lives. It does this work through its diverse network of progressive lawyers, law students, judges, scholars, and many others, which now includes more than 200 student lawyer chapters across the country. If you're an attorney member of ACS, we hope you'll get involved in your lawyer chapter or consider mentoring a law student. If you're a law student, you can work with National to get connected with your lawyer mentors in your area. As a general housekeeping matter, we'll save some time at the end for questions, which you can submit using the Q&A function in Zoom. Now, for the moment you've all been waiting for, we're thrilled to be joined today by two very special guests who are the perfect experts to discuss reproductive rights in America today. We have Tracy Skaddan, General Counsel for Planned Parenthood of the Pacific Southwest, and Leah Litman, Assistant Professor of Law at the University of Michigan School of Law. She's also a member of the ACS Board of Academic Advisors. Now, I'll have Tracy Skaddan start us off with a brief historical recap on abortion restrictions in the United States.
Great, thank you. Thank you all for joining us today, and thank you for having me to talk about this really important issue that has been on my mind greatly since, well, probably since I was born and knew anything about abortion rights. So we have seen over the years exponential expansion of abortion restrictions proposed or introduced into states. And it is one of the reasons why it is incredibly important for people to vote so that they have governors in their states that are making the decisions and signing these laws that are brought up through the legislature. There are, of course, been other heartbeat ban abortion restrictions proposed, and they have each been enjoined, and we're going to talk about the details of this later when we talk about SB 8 in Texas, but they have been blocked because they are unconstitutional based on precedent of the United States Supreme Court. We've also had unreasonable building requirements. We saw that in Whole Women's Health in 2016, and prior to that, there were several years where abortion providers had to close down in Texas to comply with the legislation that was enacted for a period of time. And we also saw that in the June Medical Services case, where the Supreme Court struck down those abortion restrictions because they were unreasonable, there was no medical necessity to it, and it would have proposed an undue burden on women for not being able to access abortion. We have parental consent notifications across the country where minors are required to get their parents' consent, which is very damaging and dangerous for many minors across the country. We have ultrasound requirements where you might be forced to look at an ultrasound and be counseled on what is inaccurate medical information about an ultrasound, or even inaccurate medical information about medication abortions. There are legislation for requiring burial of a fetus tissue remains after an abortion, all sorts of things. Specifically, I'll mention Indiana. Indiana, where Justice Coney Barrett is from, ban telemedicine abortions and requires that patients be provided scientifically inaccurate information about the reversal of the medication abortion. And, you know, one of the things that's very damaging is the fact that there is so much misinformation put out there for individuals. And what we really need to highlight is the importance of comprehensive sexual education. Also, we have a 20-week ban. North Carolina, Georgia proposed the 6-week ban. Also, that has been blocked. Missouri has an interesting ban on its books that has gone up to the courts. It's a 8-week, 14, 18, and 20-week ban. So if the 8-week one doesn't work because it's unconstitutional, they just keep moving the goalpost to see if they can at least get one ban in there. And then we have the Arkansas ban, which is probably the most recent and is the most restrictive of all if it were to be able to go into effect. The Arkansas ban was signed in March of 2021 by the governor, and the law bans all abortions except to save the life of the pregnant mother in a medical emergency only. There are no exceptions for rape, incest, or fetal anomalies. The law also makes performing an abortion a felony with a $100,000 fine or imprisonment up to 10 years. Now, a federal district court temporarily has blocked that from going into effect, while the lawsuit also goes up through the court system. One of the things I'll say about restrictions in general across the country is they pose significant barriers for women, disproportionately impacting low-income women, women of color, women with disabilities, women who already face systemic barriers to accessing quality health care. So it's a very serious issue that we're facing across the country.
So what legal challenges, Leah, can you see to SB 8, either state or federal?
So there are already several underway, and so it might be helpful just to go through the ones that have been filed. So there is obviously the abortion providers lawsuit challenging Texas SB 8 in federal court. That lawsuit is in some ways the most typical and representative of, the kinds of challenges to abortion restrictions we have seen thus far. It was a lawsuit by the people who, would be targeted under this law, arguing that the law was unconstitutional and therefore shouldn't be allowed to go into effect. And they were arguing that the law was unconstitutional because it violated, the right to decide to have an abortion that the Supreme Court recognized as encompassed within the general constitutional right to privacy in Roe versus Wade, and then later affirmed in Planned Parenthood versus Casey. So one strand of challenge is just a very typical challenge in federal court, arguing that this law, by effectively prohibiting abortions that occur before viability, violates the right, that was established and recognized in Roe and Casey. But there have also been some other lawsuits that are worth noting because they might end up being the vehicle, in which a court is actually able to determine whether SB 8 is constitutional. One of those lawsuits was filed by the United States against the state of Texas. That lawsuit is different since obviously most abortion litigation proceeds where the people who, are either denied the ability to have an abortion or the abortion providers who would be, shut down or subject to criminal penalties are usually the people to challenge abortion restrictions. But the United States stepped in to sue the state of Texas here, in part because Texas designed SB 8 in order to basically evade, lawsuits by people who would be subject to Texas SB 8. So the United States chose to sue the state of Texas after the United States Supreme Court basically said that the abortion providers lawsuit hadn't sufficiently established that they were entitled to an emergency injunction or relief against Texas SB 8 that would prevent the law from going into effect. So another possible challenge is the United States lawsuit against Texas. That lawsuit both asserts that Texas SB 8 violates the constitutional right to abortion and is limiting people's access to abortion in Texas, but it also argues that Texas SB 8 is interfering with a variety of federal programs that require federal officials to assist people in obtaining an abortion if they choose to have one. So, for example, under federal regulations, members of the military are entitled to have abortions, particularly in cases of rape or incest. People who are in federal custody, either immigration custody or federal prison, they are also entitled to decide to have an abortion, and federal regulations require federal officers to assist them in obtaining one. And so Texas SB 8, because it allows anyone to sue, people who help individuals obtain abortions, will potentially impose liability on federal officials or federal contractors. And that's not something states are allowed to do. States aren't allowed to tell the federal government, you federal government doing your job violates state law. So those are the two theories in the United States lawsuit against Texas SB 8, that the law is unconstitutional because it is violating people's ability to decide to get an abortion, and also that it is separately unconstitutional because it would impose liability on federal officers or federal contractors. There have also been some state cases that are both offensive and defensive in nature. The offensive cases are lawsuits filed by abortion providers against particular organizations or particular individuals who they have reason to believe are likely to file lawsuits under Texas SB 8. So a group of abortion providers obtained a temporary restraining order, essentially a preliminary injunction that prevents members of Texas Right to Life from bringing lawsuits under Texas SB 8. But what that lawsuit does is it prevents members of that organization, Texas Right to Life, from bringing these lawsuits, but not everyone else. And in part because it doesn't afford relief against any enforcement of Texas SB 8, abortion providers have not been able to resume providing abortion care, even though they obtained essentially an injunction that prevents members of Texas Right to Life from suing them. There have also been some defensive suits. So many of you might have seen the Washington Post article that was written by Dr. Baird, who disclosed that he provided some abortion care to someone, after the period permitted by Texas SB 8. After he wrote that op-ed, he was sued by two individuals who aren't connected with the Right to Life movement, but they filed lawsuits in Texas state courts seeking the $10,000 in damages that Texas SB 8 authorizes individuals to receive, if they sue an individual who performs an abortion in violation of Texas SB 8. Neither of those cases have proceeded much farther than that, but it is possible we will get some ruling about the constitutionality of Texas SB 8 in those cases, but it's also possible those cases will decline to reach the merits and find that they don't have the jurisdiction to hear these cases, which were filed by people with no connection to the abortion providers, no connection to the patient who received abortion care, and therefore weren't injured, in any conventional understanding of the term.
And Leah, may I add to that PPFA is one of the plaintiffs in some of the state proceedings. And to set the stage, I think it would be helpful to talk about what SB 8 actually does, which you did, but I want to expand on it just a minute. So it effectively bans abortion at 6 weeks, around 6 weeks, whenever a fetal heartbeat is detected. And obviously, we all know women do not even know they're pregnant typically at that time period. And if they did know they were pregnant, they would really have very little time or resources to get the resources and access they need if they wanted to go have an abortion. What sets this apart from other abortion restrictions is, number one, it's been enacted. It has not been enjoined. It has not been stopped. And the Supreme Court had an opportunity to do that, and they chose not to, which is very telling about where the Supreme Court is right now and the makeup of it. And the second thing, that's what you alluded to and spoke about, was that rather than being directly enforced by state officials, typically, prosecutors or professional licensed boards or state health departments could be the ones enforcing a restriction on abortion. It allows private individuals, not just who perform, but who intend to perform an abortion, and not only who perform or intend to perform an abortion, but who aid and abet in performing or intending to aid or abet. So the law's new. We don't know really how it's going to play out. And as you mentioned, there's a lawsuit, as far as we know, one by two individuals against that doctor. And interestingly enough, the Washington Post reported that one of those individuals basically said, hey, this is a win-win for me. I just want the money, because the recovery is a minimum of $10,000 if you win. What's also striking about this SB 8 is that defendants, if they win a case against them for violating SB 8, they are precluded from seeking attorney's fees or costs. So they bear the cost. The targeted defendants, the targeted providers bear the cost, regardless of the merit of the case. So this is really what sets SB 8 apart from all of the other restrictions we've seen so far, including the most terrible Arkansas case that I mentioned a minute ago, because it's blocked.
And Tracy, has Planned Parenthood already seen the impact of SB 8 since it was enacted?
Immediately, yes. There are 3 Texas affiliates, and they are all receiving incredibly high call volume with women who are scared. They don't know what to do. They don't understand what's going on. They don't have resources. Patients who, a patient came in one day, no heartbeat, but it was a 2-day procedure. They came down the next day, there was a heartbeat. And now that person had to be turned away. Or a woman who already had multiple children, who did not want to have another child and was unable to leave her children to go get the abortion in another state. It's really devastating what's happening. We saw some of this right before Whole Women's Health was decided by the Supreme Court. We saw women traveling hundreds of miles. In those cases, half of the abortion providers in the state of Texas closed down and were not able to provide abortion services. This time, all of them have stopped, except for perhaps that one doctor who may be continuing to do his job, as he stated, as a medical professional that he believed he has a right to do. But it is a real serious impact. And what we do know is when people do not have access to abortion, they will perhaps try to manage their abortion themselves. We saw a 7% increase in that right before Whole Women's Health was decided, and the maternal mortality rate increased. We do know that women will not travel typically by another way other than a car. So they will have to drive. Well, the 2 nearest places for women in Texas are Oklahoma and Louisiana. Both of those states have restrictive abortion on the books. And depending on what happens in the spring, when SCOTUS will decide this very important Mississippi case, we will know whether there's even access in those states as well.
That's a great segue to discussing the Mississippi case. Leah, can you tell us the specifics of what the court will be deciding in Dobbs?
Sure. So Dobbs involves a similar ban that, restricts providing abortion care more than 15 weeks after a person's last period. But it doesn't have the Texas twist in that this prohibition is actually enforced by state officials. Because it is, an abortion ban that is structured in the more typical way, the lower courts, of course, enjoined its enforcement, since it is obviously unconstitutional under Roe and Casey, because it prohibits people from deciding to have abortions before viability. And Mississippi concedes that the law does that. So when Mississippi originally asked the court to hear this case, they said, well, we want you to take this case because we want you to clarify that Roe and Casey don't actually prohibit states from banning abortions at some points before viability, but not all points. So when the court decided Roe and Casey, it said, because people have a constitutional right to decide to have an abortion, states cannot take away from people the ultimate decision about whether to have an abortion before viability. They also said that states also cannot impose what are known as undue burdens on the ability to decide to have an abortion. So short of an outright ban on abortions before viability, states can't enact procedural obstacles that make obtaining an abortion too expensive, too onerous, too difficult, and so on. And those are, the most recent restrictions that the Supreme Court has heard, both in June Medical and in Whole Woman's Health, not restrictions that prohibited abortions before viability, but restrictions that required doctors to obtain certain credentials that were so difficult to obtain that it dramatically reduced the number of abortion providers in the state, or requirements that obligated abortion providers to comply with the requirements applicable to ambulatory surgical centers that would have required millions of dollars in expenditures, building new buildings, that did not have any safety or health purpose, so on and so forth. But the core of the abortion right has always included, at a minimum, the ability to make the ultimate decision about whether to get an abortion. So when Mississippi originally asked the court to hear this case, they said, okay, well, yes, let's assume you have a constitutional right to decide to have an abortion. That shouldn't mean you have the constitutional right to have an abortion at any point before viability, as long as you can decide to have an abortion at some point before viability. So that was the original theory on which Mississippi asked the Supreme Court to hear the case. But when Mississippi had asked the Supreme Court to hear the case, that was before Justice Ginsburg had passed away. So they were arguing to a different court than the current court. And surprise, surprise, after the Supreme Court granted Mississippi's cert petition, Mississippi filed a cert petition now before the 6-3 conservative Supreme Court with Justice Barrett on it. And Mississippi's primary argument is asking the Supreme Court to overrule Roe and Casey. And then its alternative argument is, if you don't overrule Roe and Casey, then say, well, states can prohibit abortions at some points before viability, rather than, and maybe not at all points before viability. But that would still be a dramatic and consequential refashioning of Roe and Casey, even if the Supreme Court doesn't utter the words, Roe and Casey are overruled. To understand why, you need not look any further than the brief Texas literally filed today in the lawsuit in which it is the defendant, against the United States. In that brief, Texas is arguing that SB 8, which again prohibits abortions performed more than 6 weeks after a person's last period, it says that's not a ban on abortion. We are just shifting the time window in which abortions can occur. So they're making the same argument that Mississippi is making about the 15-week ban. We're not banning abortions. We are just prohibiting abortions at some points before viability, maybe most points, maybe all points for some people. But again, by opening the door to the possibility that states can prohibit abortions at some points before viability, the Supreme Court would basically be inviting all of the lower courts to allow these restrictive abortion laws to go into effect. And in some ways, that is the entire game, as Tracy was suggesting, because when you allow these laws to go into effect, some people in some states are not going to be able to get abortions. They are not going to be able to travel out of state and make it to a state with, less restrictive abortion laws because they don't have the money, they don't have the time, they don't have the resources, they don't have the job flexibility to allow them to do that. And second is, if those laws are allowed to go into effect, they could result in some clinics shutting down. And even if the laws are later invalidated, let's say a year or 2 years or 3 years after the case is finished, there is no guarantee that a provider would reopen if it's been, shuttered and closed for some number of years. Tracy mentioned the clinics that shut down after one of the restrictions from Whole Woman's Health versus Hellerstedt went into effect. That restriction was later invalidated, but not all of the clinics reopened. And so again, if the Supreme Court in Dobbs says we're not overruling Roe and Casey, but states can prohibit abortions at some points before viability, that is going to be a massive shift with huge consequences for access to abortion care in the United States.
Thank you. And along those lines, what are your predictions about the outcome in Dobbs, specifically in light of Chief Justice Roberts' dissent in SB 8?
I'll chime in. First off, Leah, that was an excellent description of the Mississippi Dobbs case and the potential outcomes. What's interesting about the Dobbs case is that I would argue it is unconstitutional as well as SB 8 because of the viability standard that was set and upheld for nearly 50 years. And overturning, well, not overturning, let's say, allowing states to make decisions on behalf of women regarding when they are allowed to have an abortion pre-viability would be unconstitutional under our current makeup and framework of Roe versus and Casey. Now, Justice Roberts joined the majority in the June Medical Services case because he said it was basically identical case to a Holman's Health case, and he truly, maybe because he's Supreme Court Chief Justice, or maybe because he really truly does believe in the sanctity of precedents. And however, in that case, he did also invite another abortion case that might just be a little bit kind of easier to approve of a state's restrictions. So I frankly think there are a couple possibilities of outcomes, but what Leah spoke about with respect to upholding Mississippi's ban, and perhaps it might be a narrower opinion that reframes the viability framework might be the most likely outcome. Although at the same time, I do wonder what Justice Roberts is going to do, because the Dobbs case would also be unconstitutional under, or the restriction in Mississippi would be unconstitutional under our precedents, which is what he based his decision in June. But because we no longer have somebody else on the court like a Justice Ginsburg, who would have been that person to shift in SB 8 and perhaps shift this decision in the Dobbs case, the outcome does not look promising. I think that what will happen is that if the viability is changed framework from the outcome of the Mississippi case, there will be probably a good 11 or 12 states that will instantaneously enact their trigger laws, which will ban abortion and restrict abortion to whatever level that they're allowed to under the decision that might come out. And what I very much fear is, even between now and then, is that other states like Arkansas, like Arizona, like many others, are going to do copycat SB 8 laws, because SB 8 is happening. It is in live action. And even though the Justice Department might be able to get an injunction, it also might be a temporary injunction, because we know what will happen. It'll go up to the Fifth Circuit, and the Fifth Circuit will probably strike it down, which it did so eloquently in the SB 8 case. And so we're looking at a reality of 20 to 24 states across our country that will seriously limit or ban abortion if they can, to the utmost dangerous outcome for women.
Thank you. And talking about packing the courts with conservative judges, how is that impacting legislation for reproductive rights?
I mean, it's of course impacting not only the legislation that states are enacting, but also the arguments that they're willing to make in court. Some people have described Texas SB 8 as this super clever law, that allowed Texas to evade the strictures of Roe versus Wade and just completely befuddle the courts, and they didn't know what to do with it. But the reality is that Texas SB 8 was only allowed to go into effect because of who was on the Supreme Court and who was on the U.S. Court of Appeals for the Fifth Circuit, that heard the request for a stay of the district court proceedings. So of course, the composition of the Supreme Court is affecting the type of laws that states think that they can get away with. And it's also affecting the arguments, that they are making in court. I mentioned the example of the change in Mississippi's arguments in its briefing. When it thought it was arguing to a 5-4 court, they were saying, don't overrule Roe, just allow us to prohibit abortions at some points before viability. And now that they're arguing to a 6-3 conservative court, it's let's overrule Roe. So of course, the composition of the Supreme Court, of course, the composition of the courts of appeals are influencing what states think that they can get away with, not only in court, but, in enacting laws that they will, defend in court, sometimes on the merits, sometimes not. I also think the argument that I noted that Texas made in its papers today is another example of no one would think Texas could get away with that argument if there was a 5-4 Supreme Court that, split the other way. 5 justices who were appointed by Democratic presidents. Imagine telling those justices that a prohibition on abortion more than 6 weeks after a person's last period was merely shifting the time window in which people could have abortions rather than outright banning abortions. No one would think that argument would even go over, with a straight face. So, of course, the composition of the federal courts is influencing the laws and the arguments that we see made in defense of those laws today.
And, we can't deny that this is a political issue. It's no longer a legal issue. It's no longer a healthcare issue. It's a political issue. And governors, legislatures, federal court judges, and Supreme Court judges should not get in the way of women's deciding how to live their lives and planning their future. And Planned Parenthood is certainly one organization across the country that believes that women can make that decision on their own and trust them to do so with the help of their family, their faith, their medical provider. And what we have instead, as we are going backwards in time, is we have the courts and now perhaps the Supreme Court making a decision that will really impact women's lives in a very, very dangerous way. And at the same time, we know this is such a controversial issue, and the Supreme Court knows right now that people do not like what they did in SB 8. And do they care? Does Supreme Court care? I've heard both sides. Well, one could argue, well, persons like Amy Coney Barrett and others, they don't care what the opinion is. But at the same time, she's out there campaigning about the legitimacy of the non-political decision-making of the Supreme Court. And Anthony Thomas is out there doing the same. So it's a fascinating time, but it really sheds light on how the abortion conversation continues and continues and continues, and probably will for the rest of my lifetime, in a political way.
And what other rights are potentially implicated by a decision in Dobbs?
I think definitely rights to access contraception, like Griswold versus Connecticut and Eisenstadt versus Baird. I also think rights to sexual intimacy and sexual privacy, like Lawrence versus Texas, are implicated. And I think rights to marriage equality, in Obergefell versus Hodges, are implicated as well. And I say that, both for conceptual reasons and also just, descriptive, this is what is happening reasons. So conceptually, the attacks on Roe are all premised on the idea that Roe is illegitimate because the Constitution doesn't explicitly mention abortion. And at the time of the founding or the ratification of the 14th Amendment, there wasn't, a uniform tradition of states allowing access to abortion. But all of those same arguments apply to other rights as well, right? Like the text doesn't mention contraception. The text doesn't mention, a right to sexual intimacy between consenting adults. And if you look back at the founding, there isn't a specific history of states, not criminalizing contraception, or states, permitting access to various forms of contraception and whatnot. And so the arguments that people make against Roe are conceptually, equally applicable to other rights that the Supreme Court has recognized as well. And some of the people who are asking the Supreme Court to overrule Roe and Casey have, again, reflecting the kind of changing nature of the federal courts, and the Supreme Court in particular, are now filing briefs asking the Supreme Court to make clear that those other decisions are vulnerable as well. So Jonathan Mitchell, who's one of the authors of Texas SB 8, filed an amicus brief in Dobbs, a Mississippi case, inviting the court not to overrule Griswold, Lawrence, and Obergefell, but to leave those decisions hanging by a thread because they are equally lawless and have all of the same flaws as Roe. So conceptually, the attacks on Roe are also going to leave vulnerable other constitutional protections. And I think the people who are agitating for the courts to overrule and limit Roe are not content to stop with Roe. You think back to the 2016 Republican Party platform that promised to appoint justices who would overrule Roe versus Wade. That's not the only decision that they promised the justices they would appoint would overrule. They also promised to appoint justices who would overrule Obergefell versus Hodges, as well as the decisions upholding the Affordable Care Act. So I think that we shouldn't expect this will stop with Roe. It will continue after.
I couldn't agree with you more. And we cannot deny that it is an absolute platform to actually limit access to birth control. And as crazy as that might sound, and as real as that, or as unreal as that might sound to some people, there's certainly been years and years of people thinking that Roe was always safeguarded. So here we are, and Roe is not safeguarded, and agreed, perhaps even birth control is not, which is hard to swallow.
Can we talk about the dangers of overturning Roe? Specifically, how were things before Roe for women?
So before Roe, women accessed abortion in any way they possibly could, and women died as a result and or ended up in hospitals. So it's one of the reasons why Roe was brought forth and decided, because women's lives were in danger. And what we're perhaps going to see is half the country, again, restricting or banning abortion, women not being able to get an abortion. It's not easy. Think about the logistics of if you have a family, if you have a job or two jobs, and knowing that you're pregnant and are not ready to have that child for whatever reason, which is should be your personal choice, you cannot access an abortion. And unfortunately, we know what women might do. And so again, it's a dangerous outcome.
And what's the percentage of women who are impacted by overturning Roe?
Millions of Americans, millions of women who are of childbearing age are impacted, even in Texas right now. So millions and millions of women will be impacted if abortion is not continued to be a safe and legal option, pre-viable for women across the country. And also I'll add that other states might try, and we're already working on that now with respect to SB 8, but are not going to be prepared to take care of women who actually can leave the state or the states, depending on how many states have legislation somewhat similar to SB 8 or in the Dobbs case.
Thank you. Now, moving on to affordable childcare and parental leave. What are your thoughts on included in the discussion of reproductive rights, talking about the right of parents to take time off of work to care for their children, or time to leave work after giving birth, and access to affordable childcare, as the cost can be exorbitant?
I was going to say, look, if part of the opposition to abortion is we want people to have children and we want to enable them to make, reproductive decisions that allow them to have children, then we should want to support them if and when they do have children. And part of supporting people who have children is allowing them, to remain in the workforce if that's what they want, or if that's what would allow them to care for their family. So this is very much related to the issue of facilitating people's reproductive decisions and allowing them to make the choices that they want to. I think it has been a deeply, revealing last year and a half where we have seen, with the COVID pandemic, people just being completely willing to outsource childcare to families and just say, you need to make this work. And that has been disastrous for, many women in the workforce. And we are likely going to see the, repercussions and fallout from the last year and a half for decades to come. But I think this is very much part of the movement for reproductive rights and justice. And it is, as I was saying, because it facilitates people's ability, to make reproductive decisions for themselves.
And let's remember that the reality is that the majority of women who are impacted in these decisions and in the lack of childcare and the lack of parental leave are low-income women, women who live in rural areas, again, already facing barriers to getting healthcare and other things. And I think you mentioned the Affordable Care Act, and when we were talking about birth control, reminded me that, the birth control mandate, what a wonderful thing to have a birth control mandate for insurance providers. And you can see how that, is continues to be a barrier to women, even with their, employers' health care. So it's a reality, and it's getting worse, not better. The other reality part, I think, is that people are beginning to understand by having webinars like you're putting on, that this is actually happening in real time. And what we're seeing, we're having, marches on Saturday, we're seeing people speak up. And unfortunately, I always used to say the pendulum always swings, particularly in politics, but I speak to my daughters all the time about the pendulum takes a really long time to swing at the Supreme Court because of the lifetime terms. And so we don't know what's going to happen with the Supreme Court. We don't know. Justice Breyer perhaps should be retiring soon. That's another topic we could talk about. But we don't know, right? I mean, really, what's gonna happen? But what we do know is that for now and for the foreseeable future, we have a very different makeup from the Supreme Court, and it is political, and it is below it is the stacked federal court justices that we spoke about earlier.
Thank you. And generally, what do you both see on the horizon for this arena?
A lot of the work will have to be done at the level of the states. And I think it's also important to connect this work not only to the broader reproductive rights and justice movement, but also to the movement for voting rights. Immediately after Texas enacted SB 8, they enacted restrictive voting laws, and they're now in the midst of thinking about, adopting some redistricting lines that would make it harder to vote out the politicians who adopted this law that isn't supported by a majority of the United States and isn't even supported by a majority of Texans. So if you want to actually have the ability to vote out elected officials who are enacting policies that you don't support, making it easier to vote and making elected officials more responsive to elections and popular sentiment is an important part of this project as well.
We did not plan these questions and answers, but I was just about to talk about voting rights to that question. It's a serious issue that people need to be working on. And even if you are in a state that is protected in terms of your voting rights, perhaps people should be working, doing phone banking, whatever it takes on voting rights across the country. And it is the most probably important thing right now that our country is facing to jeopardize our democracy. So speaking up and really becoming an activist in something that interests you, like the abortion rights or LGBTQ or voting or Black Lives Matter, whatever it is, do your part, because it does take a village, and it takes a team, and it takes fighting, and we will not give up this until we are in a better place.
Thank you. Now, we reserve some time at the end right now to take on some Q&A questions. Attendees, feel free to type your questions in the Q&A function. All right. The first question is, do you see the USSC's refusal to stay the Texas law as a standing issue, as it was portrayed, or a de facto substantive decision?
So it wasn't just a standing issue. So they noted numerous procedural questions related to, whether the plaintiffs were entitled to an injunction. In addition to questions about standing, they said maybe some of the state officials were entitled to immunity, specifically the state courts. Maybe other state officials weren't proper defendants because they weren't involved in the enforcement of the lawsuit, so on and so forth. The reason why I think that this is definitely related to the substance is because the court has issued emergency relief in other cases involving other constitutional rights, even where there was some procedural uncertainty. So think about some of the coronavirus health measures that the Supreme Court enjoined or issued various forms of emergency relief against. The New York coronavirus policy wasn't even in effect or applicable to the plaintiffs at the time. The court nonetheless enjoined it based on the possibility that the policy would apply to the plaintiffs again in the future. So in other contexts regarding other constitutional rights, the court is more than willing to overlook procedural uncertainties in order to grant emergency relief, to enforce constitutional rights, or to preserve what it perceives as the status quo. So it's not so much that what the court said is inevitably and inextricably related to the substance, but if you look at what the court did in the SB 8 case versus what it did in cases regarding religious liberty challenges to coronavirus health measures, as well as what it did in cases involving the last minute executions that the Trump administration carried out in its waning days, the court overlooked procedural uncertainty over procedural uncertainty in order to grant forms of emergency relief to preferred constitutional rights. And so in light of those cases, it is very hard not to read Texas SB 8 as an indication of the court's views about the constitutional right to an abortion.
And our next question is, will a rise in contraception then have to be banned too? Hobby Lobby, and they're not allowing birth control as a covered expense. Will more employers join this discrimination too?
Perhaps, yes. We're going to have to let it all play out. We don't know what the United States Supreme Court is going to do and what their parameters are going to be. And we also will be monitoring what comes up to the courts, what's going up through the circuit courts, and what may end up in the SCOTUS for next year's term. With this kind of conservative makeup of the Supreme Court, it's likely that a lot of things that many of us, perhaps on this call, won't like, because it takes four justices, to accept a review of a case. And the three liberals are going to need a fourth person to get something that they think might be important. And otherwise, the Supreme Court, as it's done in the past, they either block a law from going into effect, or they just deny review of it. So we'll have to just see how that plays out.
Thanks. Next question. Can states interfere with the US mail and prohibit medication abortion pills being mailed into states?
Well, I'll answer it this way. SB 8 denies abortion after about 6 weeks of pregnancy. Okay. And the medication abortion is a two-part process. There's one pill that's taken, and about 24, 48 hours later, there's a second pill that is taken. And basically a woman ends up having, in layman's terms, a miscarriage from that medical process. So the first medication pill is scientifically proven to be the actual impetus for the abortion. So if a woman takes the first pill, for example, in California, and then goes back to Texas and takes the second pill, she may have a miscarriage in Texas, but the abortion arguably happened in California. So mailing the abortion pills to a state that does not allow abortion after a certain period of time, which 6 weeks is under the time that a woman would be allowed to take a medication abortion as an option, for several weeks after that. So you could not even do that. They cannot be receiving the SB8 because they would be in violation, the medication abortion, because they'd be in violation of SB8.
And do you think that even if Breyer retired, that Joe could get a Supreme Court justice approved with McConnell in the mix?
I think as long as, the Democrats have a majority in the Senate, Joe Biden could get a Supreme Court nominee confirmed. He's been able to get several great Court of Appeals judges as well as federal district court judges approved. But I think in the event the Democrats lose the Senate and Mitch McConnell becomes Senate Majority Leader again, it is extremely possible that the Republicans wouldn't allow the Democrats to confirm a justice to the Supreme Court, or frankly, I'm not even sure they would allow them to confirm a Court of Appeals judge below the age of 60 with any semblance of a progressive record. Senator McConnell has alluded to the fact that he's not sure what he would do with respect to, a Supreme Court vacancy. And I think all evidence of past practice is, over the last 10, 20 years, Republicans have just started voting against Democratic appointments in higher numbers, and they have escalated the tactics they use to prevent Democrats from being able to confirm judges. So I think so long as Democrats remain in the Senate majority, they will be able to confirm judges. When they are not in the Senate majority, it is less likely.
Okay. And that's all for our Q&A from the attendees. I do have one question of my own. What are some ways that our attendees can get involved in these issues?
Well, again, I'll say vote. Voting is the most important way. Write to your congressional members, regardless of what state you're in and what you think their sense is, and any elected officials. We cannot be complacent in any of these issues that are important to us. You can join organizations and groups that either speak about it or that are activists in some of these areas. There are action funds like ours at Planned Parenthood and the Federation that really do the political side and the advocacy side, which is a great place to start in terms of becoming active and understanding what's going on. Leah, do you want to add some?
No, that's what I would have said. I don't think there are easy solutions or easy fixes on this. I think it is going to take a lot of sustained advocacy and organization over the next several years. I think a lot of people thought, if we get through the 2020 election, it's all going to be good. All evidence is suggesting that is not the case. The fight is longer than the 2020 election. And I think is going to require organizing and action on the state and local level, as well as the federal level as well.
And I'll also add, just because we were talking about birth control and everything else, I want to just highlight again that comprehensive sexual education is so important for people of all ages, of all gender identities, to understand their bodies, and that is having accurate medical information. So when there is accurate medical information from places like Planned Parenthood and other really vetted resources, they should be retweeted and shared because that information needs to get out to the public in a way that is not clouded with myths and frankly lies about things. So that's another effort that can be made.
And we mentioned the march coming, the Women's March. It's Saturday, October 2nd. Can you talk more about that?
Women's marches are happening all over the country. There's in California, we have one downtown San Diego and one starting in Balboa Park, I think at 10 o'clock and 12 o'clock. But find out if you want to join something like that. If you haven't done a march before, it's really inspiring. And the more people show up, it does show that that teamwork effort and the need to be a spokesperson and an advocate and to be educated on these topics.
Great. Thank you. And looks like we have just a few minutes, so I'll wrap it up. I want to say a big thank you to both you, Leah, and Tracy for taking the time to speak with us today. This was a truly very informative discussion, and it's a very important issue. It's urgent, and it's one that we're living in today. And it's events like this that will spark discussions and conversations and create change in the future. So thank you very much.
Thank you for asking us.
All right.